Hi, I'm Michael Santos with Prison Professors, and in an effort to help people who are going into the system, people who've already been sentenced, we've created this blog specifically that discusses disciplinary infractions and the disciplinary code. Now, I know that nobody goes into the prison system anticipating that they're going to have further problems, but really, the prison system is a different world than a different culture than any place out here in society, and so it's important for people to learn as much as they possibly can. So under our after sentencing section, as I'm doing this on YouTube and iTunes, under the resources section of our tab of our website at prisonprofessors.com, I have this section called resources, and under resources I have a section that is called after sentencing, things that people need to be thinking about after sentencing. And if they go to that index, they're going to find this article here on disciplinary infractions, which I am going to read right now in case you want to be consuming content while you're driving, and you could listen to it on our iTunes podcast, or if you want to watch it on YouTube, or if you're in prison and you're getting this content through our relationships with different tablet-based providers or institutions. You can follow along as I read. So to get out at the earliest possible times, learn how to avoid disciplinary infractions while serving your sentence. Now, at the top of the article, I provide a link to the program statement in the Federal Bureau of Prisons so that people can see exactly what I'm talking about. And I highly recommend that anybody that has been sentenced to prison become familiar with that program statement, because it can save you a lot of challenges and problems. So let's give these descriptions to people who've never been to prison before. Shots and tickets. So in the federal prison system, the vernacular for a disciplinary infraction is a shot, as in, the officer wrote me a shot because I didn't make my bed. People may also refer to a disciplinary infraction as a ticket, as in, an officer wrote me a ticket for taking an apple out of the chow hall. But during this era of the First Step Act, it is more important than ever to avoid receiving disciplinary infractions. Disciplinary infractions can interfere with a person's ability to qualify for an earlier transition to home confinement. Anyone who anticipates time in federal prison should have a basic understanding of how the inmate disciplinary program operates. Review the following information on the Bureau of Prisons Program Statement 5270 that covers the Disciplinary Code. Now, people who want to study independently should invest the time necessary to understand this code by taking the following steps. Review Program Statement 5270, and of course I've got a link that will take you right to that Bureau of Prisons Program Statement on the article itself. Now, by understanding how the Bureau of Prisons processes disciplinary matters, people will know more about how to navigate their way around them. Further, in the event that they have been cited with a disciplinary infraction, they will know what to expect and what options are available. So here is the Disciplinary Code. In the Code of Federal Regulations, it codifies a series of prohibited acts in federal prison, dividing them into 4 distinct categories that include greatest severity prohibited acts, those are series 100, high severity prohibited acts, those are series 200, moderate severity prohibited acts, those are series 300, and low severity prohibited acts, those are series 400. Now, typically, people do not anticipate receiving disciplinary infractions while in prison. Despite such good intentions, prisons can be volatile. A person can control his or her behavior, but a person cannot control how others adjust. Each person has personal motivations. Staff members may want to write disciplinary infractions to advance their career path, and people serving time in prison may violate rules that implicate others. So the wise person will take all these factors into consideration and make adjustment decisions to lessen the likelihood of exposure to disciplinary infractions. People who understand how easily they can become trapped in disciplinary problems will have a better context from which to make decisions. The more people know, the better prepared they become to avoid altercations with the disciplinary process. So what distinguishes the different gradations of disciplinary infractions? Well, first, we wanted to provide a narrative that will put the entire disciplinary process into context. So this lesson will adhere to the following order. Who starts a disciplinary infraction? What happens when an individual is charged with a disciplinary infraction? What should an individual do if officers charge him with a disciplinary infraction? And what sanctions follow a disciplinary infraction? What steps can I take to minimize my exposure to the potential of a disciplinary infraction? These are all questions that you should have the answer to if a judge is sentenced you to federal prison. You want to know this as early as possible. So who starts a disciplinary infraction? Well, the culture of confinement differs from other cultures in our country. Federal prisons isolate people. In many ways, it separates people into different factions, creating an us versus them mentality. BOP policies train staff members to be firm but fair. But while people are serving time, they sometimes feel as if staff members have their own agenda. That agenda may include writing disciplinary infractions to advance their career. Just as law enforcement relies upon laws to keep citizens in the broader society in order, prison administrators rely upon the disciplinary code to keep order within the institution. The more we understand about that, the more we can put ourselves in a position to avoid complications. Because liberties, protection, and the level of due process that Americans take for granted in society do not exist in prison. For example, law enforcement officers require much higher standards of proof before they initiate actions that lead to either charges or arrests. Further, if an authority figure charges a person with wrongdoing in society, the person will have access to lawyers and judicial proceedings where he can argue for liberty. But in contrast, staff members in prison can cite a person with a rule violation for the most trivial of reasons. And once a staff member cites a person with a disciplinary infraction, the responsibility falls on the person in prison to respond. With so many possible violations, a staff member could likely find a rule violation on just about anyone serving time. For these reasons, people should learn how the system operates before they surrender. Knowledge will help people make informed decisions. That knowledge could help a person make better decisions, possibly sparing people the difficulties that can complicate time inside and threaten the potential for an earlier release date. In the Bureau of Prisons, administrators consider every staff member a correctional officer first. Employees have the power to cite people with disciplinary infractions. In other words, officers can write disciplinary infractions, but also secretaries, cooks, chaplains, or electricians. Any staff member that works in the prison can cite a person with a disciplinary infraction. So in the federal system, people serving time and staff members alike use the jargon shot to refer to a disciplinary infraction. In other words, a staff member cites an inmate with a disciplinary infraction by writing a shot. Any shot will complicate a person's journey, bringing lasting ramifications that we describe throughout our lessons. Basically, a disciplinary infraction or a shot results in further restrictions or liberty. For example, if a person receives a shot and authorities affirm the charge, the sanction may include reduced amounts of good time, loss of privileges, and limitations on a person's contact with family or community. The process of issuing a shot follows. So first, a staff member suspects that a person violated the disciplinary code. A staff member may become aware of that violation in any number of ways. Here's some examples. Another person may tell a staff member that he knows someone else violated a prison rule. A staff member may observe a person violate a rule. Routine surveillance from security cameras may reveal a rule violation. Routine review of a phone record may prompt a staff member to cite an individual with a rule violation. A routine search of a person's living or work area may result in a rule violation. The possibility for rule violations are endless. People with the best of intentions cannot fathom themselves being involved in any type of activity that could lead to an altercation with the disciplinary code. But although people can control their behavior, they cannot control the behavior of others. Developing a higher level of critical thinking skills will help a person through a more successful journey in prison. So here's an example of a disciplinary infraction. So the culture of confinement differs in significant ways from any other area in society. Perhaps, here's this example, okay? Margaret wanted to help her husband, John. John surrendered to prison after a jury convicted him of violating securities laws. He didn't have any experience with the prison system, and as such, he did not know anything about the disciplinary code or how severe it could be. Nor did John know how to prepare himself before he surrendered. When John surrendered to serve his 36-month sentence inside a minimum security camp, he intended to observe every prison rule and return to his family without causing any further disruptions. Unfortunately, John's journey did not begin well. When John surrendered to the camp, authorities did not have a copy of his PSR on file. John didn't have any idea of what steps he could take to avoid the complication before he surrendered. John's defense attorney was exceptional at negotiating a favorable sentence. But on the other hand, the attorney did not have experience in dealing with all the nuances of federal prison. As a consequence, John got off to a bad start. Without a PSR on file, administrators at the prison camp sent John to the special housing unit. In other words, they locked him in the hole. The SHU is basically a jail within the prison. Authorities send individuals to the SHU as a sanction. They also lock people in SHU if they choose to conduct an investigation. In John's case, the authorities wanted to investigate what happened to John's PSR. John didn't have any idea what the staff members were talking about when they said that they didn't have his PSR, nor did he know the implications that would follow. Guards took John to a cell and locked him inside. The staff informed John that he would remain in the SHU until they could locate his PSR. While locked in the SHU cell, John did not have free access to the telephone. Basically, the SHU cell was a concrete windowless bunker. It contained 2 metal racks bolted to the wall that would serve as a bed and a thin mat on each side. It had a stainless steel toilet and sink. Other than gang markings that decorated the walls, that was it. John paced in the cell for 2 days before an officer allowed him to use the telephone. When a guard brought him a phone, the only phone number that John could dial was his wife's number. He called Margaret. When John spoke with her, he told her that there was a problem with the PSR and that he needed to talk with his attorney. Margaret, not knowing the rules, patched John through on a 3-way call. John explained the problem to his attorney, and his attorney said he would look into it. All seemed fine until later that evening when a guard stopped by John's cell. The guard called John to the door of the SHU cell. Then he cited John with a disciplinary infraction for abuse of the telephone. John didn't know what the guard was talking about. Rather than listening, the guard proceeded to read John his Miranda rights. When the guard told John that he had the right to remain silent and that anything he said would be used against him, John's legs began to quiver involuntarily. He didn't understand. He couldn't believe that the officer was charging him with an offense. An officer who had been monitoring inmate telephone calls charged John with making a 3-way phone call. John said that no one had told him that he wasn't allowed to make a 3-way phone call. He asked his wife to patch him through to his attorney because he wanted to resolve the issue of the missing PSR. The guard then made a note of John's comment on the disciplinary infraction. 2 days later, a disciplinary hearing officer presided over a hearing to resolve the matter. When the DHO read that John admitted to instructing his wife to make the 3-way call, the DHO found John guilty of committing the prohibited act. The DHO imposed the following sanction: 1 year loss of telephone privileges, 6 months loss of visiting privileges, 1 month loss of commissary privileges. John protested, saying he would need to use the phone to communicate with his family. The DHO listened patiently, then told John that he should have thought about his family before he broke the law. John did not surrender to prison with an intention of violating any prison rules, yet the system did not accommodate him. Fortunately, John succeeded in reversing that finding. When authorities locked John in SHU, they failed to provide him with an inmate handbook that explained the rules pertaining to the 3-way call. As a consequence, John prevailed on appeal through administrative remedy. But 4 months passed before John could use the phone or receive visits from his family. Even though a person doesn't intend to violate the disciplinary code, the bureaucracy of confinement can bring unanticipated consequences. And that's why we highly recommend that you study this program statement so that you at least have more fluency or awareness of how the disciplinary code works. So, getting a shot. Once a staff member becomes aware that a person violated the disciplinary code, the staff member writes a shot. Rules encourage the staff member to write the shot within 24 hours, but it's not absolutely necessary for a staff member to comply with the 24-hour rule. Staff members will expect all people to comply with the rules, and the shot will detail the following: time the officer became aware of the incident, time the shot was written, time the disciplinary code, or citing the disciplinary code that the inmate is alleged to have violated, and a description of the disciplinary infraction. After an officer issues a disciplinary infraction, a representative from the lieutenant's office will present the shot to the person. And the lieutenant will read the person his Miranda rights, informing him that he may remain silent and that kind of stuff. If the person wants to make a statement that he believes could exonerate him, he should make the statement at the time the lieutenant requests him if he has anything to say. If the person chooses to remain silent, the system may or may not give him another opportunity to explain. After the shot, the lieutenant who issues the shot has the discretion to dismiss the charges. Persuading a rattlesnake not to eat a rabbit may be easier than persuading a lieutenant to dismiss disciplinary charges at that early stage of the proceeding. It can happen, but not likely. On the other hand, if a person agrees to serve the lieutenant as an informant, the lieutenant may choose to exercise his discretion and dismiss the charge. Now, assuming the lieutenant allows the charge against the person to stand, the next step of the process would be for the lieutenant to investigate the allegation of misconduct. The investigation is a perfunctory process. If the person makes a statement, the lieutenant will make some inquiries to learn more. After that so-called investigation, the lieutenant will either dismiss the charge or advance the process by passing the shot along to the unit disciplinary committee, also known as the UDC. The UDC refers to the staff members who have the authority to hold an initial hearing for the inmate disciplinary proceedings. UDC officers are like the judge and the jury. They usually include a unit manager, a case manager, a counselor, or 2 out of 3. Those individuals preside over the first stage of the disciplinary hearing. During that disciplinary hearing, a staff member reads the charges against the person. Then they read the investigative report if the lieutenant completed one. Then the members of the UDC inquire whether the inmate has a response to the charges. At that point, the UDC will do one of the following. 1. Find the person as guilty of the violation and impose a sanction. 2. Dismiss the charges. Or 3. Refer the matter to the disciplinary hearing officer, also known as the DHO. The DHO is an officer that reviews and presides over the disciplinary hearings of all greatest severity infractions, most high severity infractions, and some moderate severity infractions. The DHO will repeat the process of the UDC. Then the DHO will make a final decision on whether the person is guilty of the infraction or dismiss the charges. Many people refer to the entire disciplinary process as a kangaroo court proceeding. If one prison guard writes an infraction, others within the system will take a principled path to support the process. So what to do? Well, think strategically if charged with a disciplinary infraction. A journey through prison can bring many complications, and a wise individual will choose which battles are worth fighting. We only encourage people to contest disciplinary infractions if they are absolutely innocent of the infraction. If a person violated the rule and the person knows that the staff member has the evidence necessary to sustain the charge, the person should express remorse and offer to resolve the matter informally or accept the sanction without saying anything further. In the example cited above, it made sense for John to appeal both the finding of guilt and the draconian sentence. John was absolutely innocent of the offense and the punishment was severe. He could prove his innocence. Guards locked him in the shoe within a few hours of his surrender to prison, but they never gave him a copy of the inmate handbook, notifying him of the rules. So no reasonable person would expect John to know the rules about conference calls or three-way calls. And since John didn't know the rules, he did not know that he couldn't use the phone to make a three-way call. He did not know how to respond when an unknown officer charged him with a disciplinary infraction. And he did not know how to respond when a DHO imposed a severe sanction. Now, if an individual is charged with a disciplinary infraction, the first step is to decide how he wants to respond. In the event that the person wants to accept the charges and sanction, we advise people to respond as follows. 1. I recognize that I made a bad decision and I apologize. Although it's no excuse, I've been under a lot of stress because I miss my family. And I'm going to do better and you won't have any further problems with me. Now, officers in the BOP are used to hearing complaints or denials of wrongdoing from people. So when a person immediately accepts culpability and expresses some sign of remorse, and he does so with humility and with courtesy, the officers may tend to impose a less severe sanction. But on the other hand, if a person chooses to contest the charge, he should know the appropriate steps. When a lieutenant notifies a person of a disciplinary infraction and recites the charges, the lieutenant will ask the person whether he has any comment. The person should respond as follows. I would like to make a written response that you can attach to the record. Now, the lieutenant may ask, just tell me your statement and I'll include it. But the person should insist, as courteously and politely as he can, by responding, please let the record show that I want to make a written response, and I will submit the written response within 2 hours or within a reasonable time, but I'll definitely do so today, on the same day. So a written response makes sense because you've got a person should anticipate that he's going to lose along the way and he's going to have to appeal through administrative remedies. So when an officer charges a person with a disciplinary infraction, the odds are very high that others within the system will uphold the charges and impose a sanction. Now, a fully documented written record will help the appeal. That record should begin at the earliest possible stage, which is when the lieutenant reads the charge. The written response should provide as much clarity as possible, citing witnesses if those witnesses are available. The unit disciplinary committee will likely find the person guilty of committing the offense, or guilt or innocence notwithstanding. So the sanctions. The sanctions that follow a disciplinary infraction depend upon the nature of the charges. Program Statement 5270 details the possibilities. The sanctions may include a combination of the following depending on the severity of the charge: time in segregated housing unit, forfeiture of good time, change of housing or job assignments, disciplinary transfers to higher security prisons, monetary restitutions, loss of telephone, visiting, or mail privileges, additional criminal charges. So how to minimize exposure? Well, I recommend developing a comprehensive understanding of the disciplinary code. Then, of course, avoid breaking the rules and avoid hanging out with people that don't give much thought to the rules. Sadly, living in prison can bring complications that no one expects. Sometimes the toxic culture of confinement brings consequences that a person just didn't anticipate. For example, a person may plead guilty to a white-collar crime like bank fraud or tax evasion. After receiving a sentence of 36 months, the person may learn that administrators from the BOP designated him to serve the sentence in a minimum security camp, and as such, the person may believe that he'll serve his sentence around other people who did not adhere to a criminal lifestyle. But people of questionable mental stability serve time in all prisons, just as people with mental health challenges or poor critical thinking skills live in all communities. Further, some people serve time in a camp because authorities convicted them of a trivial offense. The person may also be a psychopath, but didn't get caught for such an offense. Guards will determine where a person sleeps and with whom he shares living quarters. Sometimes the people with whom he shares quarters are, unbalanced. He will not have much insight into the values or motivations of the person who shares a cell, a room, a cubicle, or a bunk with him. If it's a person from a criminal lifestyle who chooses to engage in contraband, that person may hide the contraband in the living quarters. So what will happen if a guard discovers the contraband? If a guard finds the contraband, the guard may charge the white-collar offender with a disciplinary infraction. And at that point, the charge becomes a problem, potentially a big problem, including the potential for a new criminal charge. Staff members who will determine guilt will not take the time to look at the person's background. All they will see is the charge. They will want to support their fellow officer who wrote the disciplinary infraction, and they will want to support the process. It is crucial that individuals understand such scenarios and that they know how to respond. So always serve time with a purpose and establish a principled adjustment strategy. Participate in activities that minimize exposure to trouble, and try to serve time independently rather than participating in the herd mentality. Each person should be selective in choosing friends in prison. So the summary. Shots begin when a staff member writes a formal infraction and files the disciplinary infraction with the lieutenant office. A lieutenant reviews the shot, then calls for the person to appear before him. The lieutenant provides the person with his only opportunity to make a statement or present evidence that could lead to further investigation by the lieutenant. In most cases, the lieutenant will refer the shot to the unit disciplinary committee, and those on the committee will adjudicate the shot. The person may or may not be taken to segregation immediately upon the issuance of the shot, depending on its seriousness. People should be aware that it may be easier to find a four-leaf clover in a field than to overturn a disciplinary infraction once a staff member writes a shot. And also understand the collateral influences of disciplinary infractions. Because besides bringing immediate sanctions, disciplinary infractions adversely influence a person's custody and classification score. The form to compute a person's security level takes credit away for any disciplinary reports received within the past year. But disciplinary infractions at the 200 series level count against a person for 2 years in different ways. And disciplinary infractions at the 100 series level count against a person for 10 years. Further, if staff members find a person guilty of fighting, the BOP may consider that person a violent offender. Now that distinction will adversely influence his custody scoring for the remainder of the time in confinement. Few opportunities exist for a person to distinguish himself positively, yet there is no limit to the number of ways that a person can make his time in prison more onerous. Now this article goes on to offer more insight on segregated housing units and on the SIS, which is the Security and Investigation Services Lieutenant. And so I really recommend that you continue reading the article or becoming more aware of Program Statement 5270, because when somebody goes into the federal prison system, they are living in an environment that can really have cascading problems. So, just use your critical thinking skills and figure out what steps you can take to have a more successful journey through prison. Our goal at Prison Professors is to help people get the best possible outcome. And that typically means getting home to your family at the soonest possible time. The way to do that is to really understand the system and then to put yourself in a position to minimize your exposure to problems. We offer a lot of that information for free on our website because we want to help as many people as possible. If you're watching this inside of a jail or a prison, we encourage you to keep going through our courses. If you're watching this outside, we ask that you subscribe to us on YouTube or iTunes or wherever you get your content. My name is Michael Santos, and I want to thank you for being a part of our community. We believe in you. Thanks.